Good afternoon from Hong Kong. This is Sarah Grimmer, the Secretary General of the Hong Kong International Arbitration Centre. Welcome to those of you who have joined us to the first HKIAC webinar in a series of 14 webinars that we will be holding, conducted in 4 different languages: English, Chinese Mandarin, Korean and Russian. Today's webinar is entitled Reflections on 2019 and Responses to 2020. And it's divided into 4 parts. The first part, I will give a presentation on developments at HKIAC, looking at our cases and our work over last year. And then I'll turn to the impact of COVID-19 that we have seen at HKIAC, as well as our responses to it. The second part, we will hear from Matthew Gearing QC, Chairperson of HKIAC, and Global Co-Head of International Arbitration Group of Allen & Overy, and he will speak on the impact on contractual obligations of COVID-19. In the third part of today's webinar, we will hear from John McPherson, Partner at Control Risks in Singapore. He leads the firm's practices for, amongst other things, crisis response and recovery. And he's going to be speaking to us about the impact on business and crisis management of COVID-19. And then in the fourth part of this webinar, we will respond to any questions that you have. So please do send through any questions on the message function. And I do note that at the moment we have over 150 people on the webinar. So we may not get through all of the questions, but we'll certainly try to answer a few in the hour that we have. Okay, so I will begin, and I will speak first of all in respect of, I will give some statistical snapshots in respect of HKIAC's cases in 2019, and just in case you're interested in more comprehensive information, we have that on our website. If you go to About Us and Statistics, you find a whole range of information about our cases. But to give you an idea of what we were looking at last year, in 2019, we actually had a record year in terms of the number of arbitrations that we administered. We had a total of 308 cases. And in the last 5 years or so, we are typically administering between 260 and 300 cases. So last year was the first time that we went over 300. 173 of those cases were fully administered arbitrations, and this is in keeping with a general growth trend towards fully administered arbitrations that we are seeing at HKIAC. In 2009, as with previous years, the most common types of cases that HKIAC administered were international trade disputes and sale of goods, corporate disputes, and this category of disputes is where we saw many of our big value cases. You see here that it represented 17% of our total cases, but actually this category accounted for 40% of the total amount in dispute across all quantified cases in 2019. And what we observe also in this category is we see many parties incorporated, or at least one party in disputes of this kind incorporated in mainland China, or the Cayman Islands, or the British Virgin Islands, and very often the latter have some mainland Chinese interests in the corporate structure. Construction disputes are also an important part of our work. Many of these cases involve Hong Kong-based disputes, but we also see in this category a number of Belt and Road disputes coming through. Those inevitably involve Chinese state-owned enterprises, and we have seen, for example, disputes arising out of the laying of power cables in the Middle East, or well drilling operations off the coast of Turkey, or deep water oil blocks offshore of an African state. Hong Kong has always been an important venue for maritime disputes, and that always makes a strong showing in our cases, as does banking and financial services disputes. Most years, we have parties from approximately 40 jurisdictions represented in our cases, but last year we saw that increase sharply to 56. And from 2018 to 2019, 25 new nationalities appeared in our cases. And those you can see on the map here, and they were located primarily in Europe, Africa, Central America, and some in the Middle East. The annual portion of international cases at HKIAC is typically between 70 and 75%, but last year we saw that increase to over 80%. And what is most notable about our international cases is that almost all of them are filed under our administered arbitration rules. A word on our administered arbitration rules. Some of the tools that are available under those rules were put to very good use in 2019. One of the most popular provisions under the rules is the expedited proceedings provision. That is designed for cases that are worth under Hong Kong $25 million, which is approximately US $3.2 million, or are of exceptional urgency. And parties can request that the proceedings be expedited, meaning that a final award will be issued within 6 months of the file being transmitted to the tribunal. Our rules also contain a suite of provisions that are relevant to multi-party, multi-contract arbitrations. Of the 308 arbitrations filed with us in 2019, approximately 1/3 or 93 involved multiple parties or multiple contracts. And in 1/4 of those cases, there were applications under our relevant provisions with respect to the commencement of a single arbitration under multiple contracts, the consolidation of one or more proceedings, and the joinder of additional parties. And amongst those applications, all matters involving a single arbitration commenced under multiple contracts were allowed to proceed at the HKIAC assessment stage. All but one contested request for consolidation was granted by HKIAC, and all 4 joinder applications were also granted. In 2019, HKIAC made 122 appointments of arbitrators and confirmed 137 arbitrators designated by parties or co-arbitrators. And of the 122 appointments, just under 55% were of individuals who can be found on our panel of arbitrators, either the general panel or one of the specialist panels. Just under 38% were appointed from our list of arbitrators, and just over 7% were appointed neither from one of our panels nor from the list of arbitrators. You should know that our panels and our list is a searchable database that is available to the public. Of all of our appointments over the year, over 20% were of female arbitrators, and over 40% were of arbitrators who had not been previously appointed by HKIAC in the 3 years prior. In 2019, there were a number of developments at HKIAC, but I want to focus now just on the 2 main developments at HKIAC in the year. The first was that in April of 2019, HKIAC was the first foreign arbitral institution to be granted permission by the Russian Ministry of Justice to function as a permanent arbitral institution under reformed Russian arbitration legislation. And this has significant consequences under Russian law in respect of the enforceability and validity of awards, and also in terms of procedural advantages that are available in arbitrations administered by a PAI, as opposed to what would be called ad hoc proceedings under Russian law. It also means that HKIAC is authorized to administer certain types of corporate disputes seated in Russia involving Russian legal entities, and certain types of procurement disputes seated in Russia. We can also administer certain domestic Russian arbitrations. And we will be holding 2 webinars that will specifically focus on this development, one on the 17th of June in English and one on the 15th of July in Russian. The second development I want to speak to is concerns the interim measures arrangement concluded between the Supreme People's Court of the People's Republic of China and the Hong Kong government in April 2019, under which HKIAC has been recognized as one of the 6 qualified institutions. Pursuant to that arrangement, any party to arbitral proceedings seated in Hong Kong and administered by HKIAC may apply to a competent mainland Chinese court for interim relief in respect of the preservation of assets, evidence, or conduct. And this development sets Hong Kong apart as the only jurisdiction outside of mainland China where parties to arbitrations can obtain such interim relief from mainland courts. Since the arrangement came into force in October last year, HKIAC has processed 17 applications, 16 applications with respect to the preservation of assets and 1 with respect to the preservation of evidence. Those applications were made to courts in these 9 cities. The total amount sought by applicants to be preserved in terms of assets was 5.9 billion RMB or 836 million US dollars. And court orders have been issued that cover in total 2.4 billion RMB or 340 million US dollars. And those court orders were issued by 7 courts that you can see reflected there. It is interesting to note that of all of the applicants, 66% were foreign parties and 1/3 of applicants were mainland Chinese parties. Also, by contrast, the respondents in these applications, 60% were mainland Chinese entities and 40% were foreign entities that owned assets on the mainland. We will also be holding a special focused webinar on the interim measures arrangement and HKIAC's experience under it on the 22nd of April in English, on the 29th of April in Korean, and the 20th of May in Chinese. I will now conclude by looking at the impact of COVID-19 on HKIAC's caseload, also on our hearings, and then give you an overview of the measures that we have taken at HKIAC in response. So first of all, with respect to our cases, we started to notice in late January the impact of COVID-19 on our cases. At that time, we noticed that our case flow had dropped to 1/3 of what it would normally have been at that time of the year. And we put this down to the significant impact that COVID-19 was having, particularly in mainland China, where most people and businesses were under some kind of lockdown, and it was certainly not business as usual. Once we got to February, we saw that our case inflow had normalized, and that has continued to today, except for, say, a 2-week period in March where we saw very low numbers of cases coming in. And while I can't confidently say that there is a nexus, that was around the time when COVID-19 was having a serious impact in Europe, and many of the European governments were starting to put in place their emergency measures. What about in respect of our hearings? So since late January, parties and tribunals in our cases have been grappling with the need to reschedule not only deadlines, but primarily their hearings. And through January through February, we saw this affect almost all hearings that had been booked at our centre at that time. They were either being postponed or cancelled, and in one case, a hearing was relocated from Hong Kong to London. However, a few weeks later, when the situation in Hong Kong had stabilised and the situation in London had taken a severe turn for the worst, the hearing was located back to Hong Kong. But what we noticed is really a 2-phase approach. So in those early days, we were seeing tribunals and parties postpone and cancel. That was the main reaction we were seeing. But that changed in late February and March, where we saw tribunals and parties start to respond differently. And what they were doing was instead of postponing, they were transforming their hearings either fully or partially into virtual hearings with the use of our video conference services and other e-hearing services. And this is what has happened to approximately 70% of the hearings that we have booked at the centre through April and May and then into June. And so that has been quite a noticeable shift in the response to hearings. Meanwhile, at HKIAC, since late January, we have put in place measures to protect our guests and staff, and we've followed closely the Hong Kong government's policy. We have a strict screening requirements in place for anyone who enters the premises. We have essential staff working from the office every day to oversee our hearings. And then we have systems in place such that our legal staff who are managing our cases can continue with their work uninterrupted and make sure that cases are being managed properly. So that brings me to the end of my presentation, and now I'm going to hand over to Matt Gehring. Thank you very much.
Thanks, Sarah. Good afternoon, everyone. Thank you for, or morning, depending on where you are. Thank you very much for dialing in. I have a massive subject ahead of me, and I only have 10 or 15 minutes, so I'm just going to jump across a few interesting points. COVID-19 impact on contractual obligations. Now let's start by taking a step back. You turn on the news, you turn broadcast news or web news, it's obviously and rightly full of, almost entirely dominated by COVID news, and you will hear newscasters and journalists will say this is unprecedented. And to an extent, certainly on a news level, that is right, but is it legally unprecedented? And in that regard, I have dug out, or a good friend of mine, Angeline Welsh from Essex Court Chambers in London, has dug out for me two pieces of legislation over 100 years old. But if you look closely at them, you will see that they bear some strong resemblances to the situation we are in now. Now, this two pieces of legislation from what was then British Honduras, what is now Belize. The first one on your screen now is an ordinance number 20 of 1918 to facilitate the prevention of the disease known as Spanish influenza. Now, you'll have read of the similarities between Spanish influenza and COVID-19. Then if you look at the next screen, number 21 of 1918, you can see some striking similarities in respect of the legislation then and the legislation we are seeing around the world at the moment. And if you look at the right-hand page on your screen, and I won't read that to you, but you can see that there is a prescription in respect of every vessel bringing a foul bill of health into a relevant port, in this case in Belize or British Honduras. And if you then look down to clause 3, you'll see that the measures in respect of quarantine are very, very similar to the sorts of measures we are seeing all around the world today, not just at the Hong Kong International Airport and on Hong Kong's borders, but all over the place. You'll see subparagraph 1, the sick may be isolated. 2, other persons may be subjected to detention for the prescribed period from the time of landing. 3, the vessel may be fumigated. 4, persons employed in discharging or landing the cargo may be subject to detention for the prescribed period, and so on. So 102 years old, but in fact strikingly similar. Tools being used then are strikingly similar to tools which are being deployed now. Now, I divide this very briefly into 2 existing disputes. At least in my practice, there's 3 trends already developing. 1, procedural issues. Sarah touched on that. How do we conduct current disputes in the light of the fact that at the moment we can't travel and meet? And that leads into lots of discussions about electronic presentations, electronic hearings, and so on. I won't say anything more about that, but just to note that that is obviously dominating the agenda. Secondly, good news for funders. Parties are wanting to and needing to pursue disputes, particularly claimants, but they lack cash. Of course, cash in quotes is king. You can read that in almost any newspaper, any online blog at the moment. Companies, particularly claimants, they need to preserve their cash. So discussions about how to get disputes and claims funded, they were topical before, but have come even more up the agenda. And thirdly, and this is in respect of existing disputes, and it's a subject in itself, is the question of calculation of damages. And the question, a seemingly dry and esoteric legal question, should they be assessed at the date of the breach or at a later date? And if it's to be a later date, it would normally be the hearing date or the later date of the award or the date of the judgment. Now, that may sound like a dry point, but it is a point actually of enormous, potentially financial significance in the context of breaches which have occurred or alleged to have occurred 1 or 2 years ago, and claimants presenting claims based on the net present value of the value lost. So, for example, the oil field or the opportunity to develop a particular project in a particular place. Now, those NPV and DCF calculations, of course, are very, very highly sensitive to market projections, whether it's to the price of the oil or the price of oil or the value of a particular market for particular goods. Now, of course, the bottom has fallen out of many of these markets. So if you run DCF or NPV related calculations now, you will be coming out with significantly lower figures. And there are cases where there may have to be dramatic downsizing of damages claims if one takes the view that damages should be assessed at a later date and not at the date of breach. But there's a lot of law, English, Hong Kong, and no doubt in many other jurisdictions, law about what is the appropriate date for assessment of damages, and lawyers are scouring it on relevant cases at the moment, I know. Now, forward-looking, new disputes. What kind of new disputes is the COVID situation, the COVID crisis bringing us? And what sorts of things are we looking at? Firstly, I would say, of course, material adverse change clauses. They are common actually in many sorts of contracts, M&A, finance, and commitment letters. And just from my own practice this morning, I pasted an example actually of a quite narrow material adverse change clause and put it on the screen there. Sometimes they're actually much broader than that. It's particularly relevant at the moment in the context, at least as I've come across it, in M&A transactions where there has been an exchange but not yet a completion. And buyers are asking themselves whether they can invoke material adverse change to avoid having to complete, or in order to force a renegotiation of the terms of the clause, because the price which they agreed as at exchange may not now, probably won't reflect the market price which now prevails. Secondly, there has been some quite considerable discussion of best or reasonable endeavours clauses. There are absolute obligations, obviously, in contracts. There are also many obligations in contracts that require something less than an absolute obligation to complete, so best or reasonable endeavours. And the question arises whether one can now say, in all sorts of different contexts, that a failure to do something has been caused by the COVID situation, but the party is not in breach because it used its best or its reasonable endeavours, as the case may be, to perform the relevant obligation. There are a lot of cases from, I wouldn't say analogous, but previous crisis situations which have then gone to litigation in common law jurisdictions. One such case is the case of Empurious New Homes, which I put the citation for on your screen, which was a case where the developer had agreed to use its reasonable efforts or endeavours to complete the construction of some houses, some properties by a given date. They said that they were unable to do so because they couldn't get funding because of the collapse of Lehman Brothers and the global financial crisis. And they said that even though they weren't able to do it, they were not in breach because they had nonetheless used their reasonable endeavours. Now, on the facts of that particular case, that argument didn't succeed, but one can see that in certain situations it may be an argument that is worth running. Then one turns to illegality. Now, this is a legal doctrine in Hong Kong English, and I think in a number of other common law jurisdictions. It's got nothing to do with how you draft a contract, but it's an underlying legal doctrine. And the short point is that performance can be excused if performance becomes illegal in the place or the necessary place of performance. So it's not got anything necessarily to do with the governing law, but the question is whether it has become illegal, necessarily illegal, to do the relevant act of performance in the necessary place of performance. It's often known, at least in English and Hong Kong law terms, as a doctrine in Raleigh Brothers, and I put Raleigh Brothers up there. So, for example, if a party had agreed to perform an event or put on an event in Hong Kong, even if it was not, say it was governed by English law, but put on an event in Hong Kong this evening, at which 20 people were present outside the HKIAC, the chances are that that party would be able to excuse its performance on the basis that performance had become illegal, because at the moment gatherings, other than in certain cases, of more than 4 people are now unlawful in Hong Kong. So the more one thinks about that, the more one can think about the potential application of that doctrine to performance of obligations in the light of the COVID crisis. Next, of course, and this is probably what you read most about, although I personally have come across it less, although it's relevant, is whether force majeure clauses can be invoked. That, unlike the doctrine of illegality, is a pure question of drafting. So you just need to look at your contract and you just need to see what has been provided for. I have put one again from my practice anonymized up on the screen there. The nexus is always something beyond either party's reasonable control, and there is almost usually a reference to act of God. In this particular clause, you'll see a reference to disease. In other clauses, I've seen more specific references to epidemics and pandemics. But there are actually also other potentially relevant trigger words there. I haven't highlighted it, but you can see the reference to lockout. That may be factually relevant because lots of people are locked out of lots of places as a result of the current crisis. And perhaps more interestingly, a shortage of any material, labour, transport, electricity or other supply or regulatory intervention. All of those might be relevant depending on the particular factual context. Now, in the context of obligations to be performed in respect of Chinese companies, as a matter of fact, not as a matter of law, the CCPIT, the China Council for the Promotion of International Trade, issues force majeure certificates and has been issuing a lot of force majeure certificates since late January or early February. And so in the context of force majeure, as between disputes with companies on the mainland, one may well see the attempt to invoke a certificate issued by the CCPIT. Now, depending on the terms of the contract, the invocation of force majeure justifies either suspension or an extension of time, and then normally the contract will provide that after a particular period, 1, 2 months, or whatever the case may be, that the contract may then be terminated. Frustration then, next concept which comes up. Again, this is a legal concept, doesn't depend on the drafting of the contract, but can be invoked where there is a supervening event without fault on either side, leading to usually the agreed performance becoming impossible, or the mutual purpose, the underlying purpose behind the contract becoming impossible. And so normally, in order to invoke that, one needs to refer to a significant change to a mutually agreed state of affairs. And again, if you look back through the law reports, or these days on your Westlaw or Lexis search, you can find examples of cases that have been invoked, not in similar situations, but situations where there was some passing resemblance to the situation we are facing now. And I've put on your screen the case, an English case from 1903, Krell and Henry, where a contract was rented for the purposes of taking part or viewing the coronation of the English king, King Edward VII. The coronation was then cancelled because the prospective king to be crowned was ill, and the party claimed successfully that his contract to rent the relevant flat in connection with the coronation was frustrated, and therefore he was not liable for failure to pay the rent. So one can easily think of potentially analogous situations now, the cancellation of the Tokyo Olympics, Wimbledon, and a whole host of, much less important, much less well known, but nonetheless important in their relevant sector events. And there has been a lot of discussion of frustration in that context. Now, finally, Hong Kong, of course, has been through this, has been through a similar situation before. The difference, of course, was that it didn't, SARS, of course, I'm talking about back from February, March 2003, and it really lasted to May 2003, didn't spread around the world in the way that COVID-19 has spread around the world. It did impact some other jurisdictions, but of course had nothing like the same global impact that COVID-19 is now having. But why it's interesting, particularly from a common law perspective, is that in the aftermath of SARS, there was a lot of litigation in Hong Kong that considered a whole host of situations thrown up by SARS, both contractual and non-contractual. I mentioned two of them here. The first is a case called Lee Ching Wing, which was a case where a block of the tenant in a block of flats that was subject to a 10-day isolation order, because a lot of people had caught SARS in that relevant block, and the effect of that isolation order was that he could not return to his flat for 10 days. And he claimed that the tenancy was frustrated because of that isolation order. The holding in that particular case was there was no frustration, as the isolation order only lasted for 10 days and the lease was for a considerably longer period. But nonetheless, one can see the potential application of at least the arguments in that case in a whole host of now COVID-19 related situations. And then another case, New World Harbourview Hotel, where a hotel tried to claim business interruption insurance from their insurer. They said that under the policy, which was the case, they were entitled to coverage if a notifiable human infectious or contagious disease occurred within 25 miles of their premises. And the claim was disallowed before a particular date, and that was the subject of the dispute, because the infectious disease, SARS in that context, only became statutorily notifiable under the relevant law, Hong Kong law, at a particular date in late March. Before that date, it wasn't a notifiable disease. So that may not have any particular contractual application. It won't. The first case, Lee Ching Wing, may. But the message really that I just wanted to give in closing is to say that even if you're not a Hong Kong lawyer or you're not dealing with Hong Kong law related questions, do think about SARS and do think about whether the apparently novel situation you are looking at may have been considered by the Hong Kong courts in the aftermath of SARS. So that is all I wanted to say. Thank you, Sarah.
Thank you very much, Matt. Now I would like to turn over to John McPherson from Control Risks. But before I do that, if I can remind people who are on the webinar that you can submit questions using the message function. And once, and we will turn to your questions at the end of the webinar. Thanks a lot. Thank you, John.
Great. Thank you very much, Sarah. And thank you, Matthew, and thank you everyone for listening. by way of introduction, I run Control Risk Crisis Cyber and Security team across Asia. I'm based in Singapore for now, after living in Shanghai and Hong Kong for the last decade. My background, my early career was working in administrative law with administrative appeal tribunals. Then I found my way into risk management, where I worked a lot with national governments on pandemic planning in the kind of 5 or 6 years post-SARS. And I thought Matthew's comments on the relevance of some of the 1918 Spanish flu laws now particularly interesting, because when we used to do national pandemic planning, a lot of the lessons we would draw from and the scenarios we would build were based on Spanish flu and that period from 1918 to 1919. And we did a lot of detailed scenario planning, most of which has held up and sadly come true. I now spend most of my time advising control risk clients all around the world when they have acute moments of crisis. So it's a particularly busy time for us. And that can be everything from compliance and regulatory investigations in politically opaque parts of the world, lots of product issues, operational issues around restructuring, and then of course increasingly around cyber issues. And then I work very closely with my colleagues all around the world in intelligence, in geopolitical analysis, and in forensics and forensic accounting. So that's kind of the context that I'm bringing over the next 10 minutes. I could talk for hours on pandemic. I'm going to keep my comments short. If you could go just to the next slide, please, Sarah. I'm going to have a particularly non-legal perspective. So hopefully that will be refreshing, and just talk through where we see things going and some of the really big challenges for organizations and for leaders in organizations. This is a snapshot from some of the monitoring that Control Risk is doing. And you can see we have a range of scenarios there. As we've reached this morning, over 1.4 million infections and coming up to 18,000 deaths in the global tracking that's been done. And with significant government and corporate disruption, I think we're very clearly in a scenario of prolonged disruption. I know many of us have been holding out hope that we would kind of return to a sense of normal fairly soon, and early predictions in February were that the world would kind of move through this fairly quickly. I think that's clearly no longer going to be the case, and I think we should be expecting to be in a period of prolonged disruption until at least the end of this calendar year, and possibly longer. And a lot of how we return to work will depend on various government interventions. It will depend on the latest medical science and the epidemiology of the virus, and how quickly we get a vaccine. So period of prolonged disruption, I'll talk through what that has meant for companies in a moment. But importantly, we're tracking two potential recovery or rebound scenarios. And those of you who are familiar with SARS will, I'm sure, be familiar with what's referred to as this V-shaped recovery. So a very sudden downturn, but also a very sudden economic recovery. And that would be a rapid kind of and consistent global rebound. We don't think that's likely. At the moment, we think a very uneven recovery, kind of a bumpy road through to the first quarter, perhaps even longer, of 2021 is more likely. So instead of a V-shaped recovery, it's going to be a kind of a skewed U-shape. So a kind of longer bottom and then a slower climb back up. That's obviously because of the complexity globally, the scale of disruption, but also the inconsistency of government response. We see that both at a national level and in many countries, inconsistency between national and then state or local governments. I think the biggest thing to immediately disrupt a return to normal will be where the medical science opinion lands on how infectious the virus is without people showing symptoms. So it has traditionally been thought that you are contagious at the very earliest onset of symptoms, and that's because of where the virus sits in the respiratory system. But latest medical studies indicate that the virus may be contagious before you are symptomatic. And that has some fairly serious implications for how governments and how workplaces, with looking at duty of care to employees and clients and customers, how they will need to control and slow down any kind of rapid recovery. If you move to the next slide, please, Sarah. So we have a couple of key organizational challenges here that I'll just talk through briefly. Matthew mentioned in his opening comments that the COVID-19 is in many ways, in some ways unprecedented, in many ways there is precedence for it. And I think when we look at the organizational and operational challenge, aside from the legal precedence, it is very clearly unique and unprecedented. And it has presented companies all around the world with some very unique challenges. And that has to do with both the disruption, the scale of disruption, and with the complexity of stakeholders and information. When businesses plan for disruption, the best practice is to assume somewhere between a 30 to 50% outage for generally a short period of time, a week, maybe two, or to assume that a very discrete segment of business is disrupted for a longer period. That might be one or two particular suppliers. It may be business in a particular location. Most business continuity plans and most assumptions in those planning do not consider a large scale international level of disruption where all of your third parties, whether it's supply or logistics, are out of business, where there's a sudden drop in demand globally, where you have to send all of your employees home to work over an extended period of time. And we will be living through this scale of disruption for many months to come. The additional challenge is, of course, the world is not going through it simultaneously. So while China is clearly at the moment in a recovery phase, the epicenter has moved to Europe and the US. We're probably reaching peak in many of those markets. We'll see it come down. But we have other places, particularly South America, Africa, and other parts closer to home in Asia, where they're just beginning their pandemic curve, and we'll see them reach peak in the weeks or months ahead. So it's very kind of disjointed. The next big challenge is just dealing with the amount of information and the complexity of information. And we have some very good sources. We have some very bad sources. We have a huge volume of information, and just determining what is relevant and useful and what sources are credible is a huge challenge for global organizations, not helped by the inconsistent kind of government response. Significant challenges for welfare of employees, lots of very fast, quick and dirty development of health and hygiene policies, lots of training being rolled out on how to deal with extreme stress and anxiety, how to manage entire workforces who are now working remotely, and then how to communicate certainty in a world where things are very uncertain, and that presents real leadership and communication challenges. We have a series of emerging risks. I think you'll all be across some of the financial risks that are being forecast. But more operationally, we have a large increase in cyber risks, taking advantage, cyber criminals taking advantage of vulnerabilities inherent in work from home environments. We are tracking very closely security situations in parts of the world where social and government disruption and lack of access to critical care and supplies will see a deterioration in security situation. And then we're seeing an uptick in compliance issues, whether that be fraud, conflict of interest, or demands for bribery. This kind of environment leads to some interesting challenges around disputes and disruptions. And the team and I are seeing kind of additional and quite rapid requests around gathering evidence, around asset tracing globally, around making discrete inquiries in some markets in order to support strategies around arbitration. The challenges of evidence preservation when you physically can't get to sites to preserve evidence or image laptops, all those sorts of operational challenges. And then issues around government policy changes, regulations, and how we kind of foresee that contributing to challenges of market downsizing, market exit, and market entry as supply chains are completely restructured. Move to the next slide, Sarah. So we have significant organizational challenges. We also have some quite personal leadership challenges in all of this. And the first is to really recognize that decision fatigue is a real thing, and it happens very quickly. You really only get 48, 36 hours of working in a very intense environment before your ability to make clear decisions begins to be impacted. And we have now situations where teams and leadership have been working fairly intensely in a very confusing situation for in some cases, 2 months or more now. There is no short-term solution to that. There's going to be a significant strain on resources to make critical corporate decisions for some time. But it is really important that we all empower alternatives, that we lead through values and principles in order to really rely on delegates to make decisions, either to keep the business running, to keep relationships, to make decisions around where we allocate resources, or to make decisions about how we respond to the crisis. We're starting to see, thankfully, talk about recovery. Matthew and I were chatting briefly before the call and talks around, we were talking around a shift in the media narrative to recovery. It's really important that companies dedicate resources now to a recovery team to look at scenarios, to be predictive around how markets are going to change, where you need to make cuts to third parties or reorganize supply chains, where you need to reorganize parts of the organization, but to be in charge of your own destiny rather than let that recovery kind of happen around you, and to get that planned in advance. And of course, for many of you, a lot of that will be planning around the support and advisory that you give, or the actions that you need to take around disputes, negotiation, resolution, and restructuring. And that's where we kind of plan to see a lot of our own recovery as well. At the end of the day, we will see, I think, quite a significant shift in the world of risk management, which for many years has been really an audit-led approach, so a top-down governance approach to how risk is managed. And I think the fact that pandemic, even after weeks of the situation in Wuhan, it didn't appear on global corporate risk registers, really represents a failure of the current approach to enterprise risk management. And I think in the months ahead, we will see moves to be far more data-focused, risk management that is agile, far more responsive, and far more scenario based than we currently see, and that will impact kind of governance. It will impact how boards need to manage risk throughout companies. I'm going to stop there so we have plenty of time for questions, and just give my thanks to everyone.
Thank you very much, John. Okay, so now we have just over 5 minutes to deal with some of the questions that have come in. So thank you to those of you who wrote in. One of the first questions that we received was this: is there any expectation in drops of arbitration cases in 2020 due to the COVID-19 crisis?
Sarah, yes, Matt here, I can deal with that briefly. I think no. I think in the very short term, as you said, Sarah, in February, for example, because of dislocation, physical dislocation, cases were not being filed, but now they are being filed again. And as I tried to canvass briefly in my presentation, it seems very likely that the enormous dislocation produced by this crisis will lead to a host of other disputes. Inevitably, many of those will be cross-border, and because they're cross-border, they'll go to arbitration. HKIAC and no doubt a host of other arbitral institutions as well.
Yeah, I think that's certainly true, and I think that there are, this question is relevant to those cases that the parties would have filed, but may delay because they have more important things that they need to think about and devote their cash to at the moment if they can't get third-party funding, or if that's not going to be an option. But so there may be a delay which may push cases to a later time in 2020 or even into 2021. And one thing that we were watching closely at HKIAC was when will our case inflow normalize, and as I said before, I think it has now. But also those cases that weren't filed that would normally have been filed, is there going to be a point where perhaps a dam will break a bit? But then there are also the claims that are arising out of COVID-19 that wouldn't have been filed but for COVID-19. And I think that that goes to some of the very many issues that you spoke to, Matt, about legal excuse with respect to breaches of contracts as a result of COVID-19, and then whether or not parties want to enter into a litigation or arbitration setting, or whether they want to preserve their relationship, and whether or not they have the ability to actually recover on their cases. Okay, so in another question we have received, how has the experience been so far with respect to the use of remotely conducted evidential hearings, in particular those involving examination or cross-examination of witnesses? Matt, do you
Sarah, I'll say something briefly about that. I think we're all having to grapple with it. I mean, it did take place before. I mean, before COVID really hit, I, for example, did a case in early February in Singapore, where I, as counsel, was in the room with opposing counsel and the tribunal and the expert witnesses. But all the factual witnesses came in via video, gave evidence via video from 2 other Asian jurisdictions. The question now, that was, I think, broadly acceptable and people were doing that. The question now is, can you have a whole hearing over several days with witnesses taking place entirely remotely? And whilst there may be some reticence to do that, I think increasingly people are thinking, well, we may well have to do it. I mean, I think certainly a 1 to 2 day hearing with limited evidence, of course you would do it by video. If it's a 2-week case and you've got people spread all over the world, so the time zones as well make it very difficult, then it may be more challenging. But then tribunals ask themselves, well, what's the toss-up? If it's, do they do it by video on the scheduled date in April or May, or do they postpone it? But if they're postponing it, how long will the postponement be?
Yeah, exactly. That's what we're seeing as well, as tribunals are, weighing the applications for postponement with the fact that actually maybe the evidence can be taken in a way that perhaps people were less or more reluctant in the past, but given the current situation, it seems to be that it's the way ahead. And we have a range of permutations that we see in the cases and the inquiries that we get here with witnesses in different jurisdictions, or witnesses in one room, counsel in another room, and tribunals in another room. So every permutation seems to be being investigated at the moment, and what technological tools are available seems to be determined in some part by the restrictions of the witnesses. So for example, we have a situation at the moment where we're looking at a witness who is in a jurisdiction where that person is in lockdown and cannot leave his apartment. And so if the hearing's going to go ahead, that's going to be on a cloud-based video conference system. And perhaps in the past, people might be a bit concerned about security issues. Of course, there are security measures you can take with cloud-based video conferencing, but these are all issues that are live and that we see on a daily basis. I have a question to you, John, and you touched upon it already in your presentation, but perhaps this question is, what do businesses need to be doing now in response to COVID-19? What would be your top 3 tips?
So my top 3 tips for now would be communicate certainty. It's really important that employees get a sense of where you are going as an organization and how you're making decisions. Particularly for larger organizations, it's incredibly difficult to do, but really important and will accelerate your recovery. Plan for return to work. In some markets, that's already happening. In other markets, it will be kind of a week, two or 3 weeks to come. But that takes very specific planning to do it with confidence. It's around health and hygiene. It's around compliance, government orders. It's around how you get an employee, a large workforce, back to work after they've been all working remotely. And the third thing is plan for recovery, but with an eye on what's going to be different, and really do some hard thinking about how the current situation fundamentally changes your business, either how you interact with clients, how we work more digitally, and the discussion around virtual arbitration hearings is so interesting, because we will all live in a world where digitalization changes the way we work. And I think that will permeate in many different ways. It's just one example of a new world we'll have to get used to. So be very deliberate and focused around what you want to change and what you want to keep. Thank
you very much, John. So we are now at the end of the hour. And so we'll close this webinar now. You can see on your screen all of the upcoming webinars and the topics and the dates and the languages. Just so you know, this webinar will be available on our website shortly. So a recording has been taken and that will be made available. So thank you very much for attending and wish you all the best. Thank you.